Brussels I regulation deals with two very broad concepts: which courts should have jurisdiction over disputes, and how judgments should be recognized and enforced in other EU member states. Brussels I regulation was and remains one of the most successful pieces of the acquis communautaire. The recasting of this regulation was desirable, and it has brought about significant improvements. My name is Marco de Benito, and I'm a professor of law at IE Law School in Madrid. I invite you to join me for a few minutes in having a quick look at the main changes of the new regulation. The new regulation was published on the 20th of December of 2012, and although it's already in force, it will only start applying after a vacatio legis of 2 years, more specifically on the 10th of January of 2015. Its official name is that you can see on the screen right now. As it substitutes Regulation 44/2001, which is also known as Brussels I regulation, we can call it Brussels I regulation recast. After a couple of years, though, when it's already applying, we'll be able to refer to it, as always, as simply the Brussels I regulation. Three key changes deserve to be highlighted in the new regime. First, abolishing the exequatur procedure, thus making judgments immediately enforceable across the EU without the need for any intermediate procedure in the enforcing state. Second, strengthening form selection agreements and adjusting list pendants to avoid parallel litigation and, in particular, torpedo tactics. This is done by requiring the courts of any member state to state proceedings where there's a jurisdiction agreement in favor of the courts of another member state. And third, clarifying that arbitration is absolutely excluded from the scope of the regulation, including any court proceedings surrounding or in support of arbitration. Let's see these changes in more detail. And let's start with the most conspicuous, the abolition of exequatur. This is a small revolution in the European procedural law of the EU and the member states. We must distinguish, in this regard, between recognition and enforcement of judgments. Recognition was already automatic in the current regime and remains automatic in the new rules. What changes is enforcement. The current rules require the enforcing party to seek and obtain a declaration of enforceability, an intermediate procedure that takes place after the judgment has been obtained and before concrete measures of enforcement can be taken. This is called the exequatur procedure. Exequatur means let it be executed in Latin. In the new rules, exequatur is abolished. No intermediate procedure is required. The judgment coming from a member state will be treated almost exactly as if it were a judgment from the courts of the enforcing country. The same idea is enshrined in the US Constitution, which reads as follows: full faith and credit. In this regard, the abolition of exequatur is a very important step towards European integration. This was the wording of the exequatur requirement. Shall be enforced when it has been declared enforceable there. When it has been declared enforceable, meaning after the intermediate procedure called exequatur. And this is the new wording. Shall be recognized without any special procedure being required. Put differently, Article 41 sets forth, as you can read now on the screen, shall be enforced there under the same conditions as a judgment given in the member state addressed. There are, of course, safeguards for the debtor. The initial draft had eliminated the possibility of challenging enforcement based on public policy. In the final version, however, the ground has been maintained. The enforcement of a judgment shall be refused if it is manifestly contrary to public policy. The second most important improvement concerns lease pendants and forum selection agreements in an attempt to avoid undesirable parallel litigation. The Brussels Convention and later the Brussels Regulation gave priority to the court that was the first to have been seized. First seized. In the recast regulation, the courts of a given member state will be allowed to deal with the case, even if the court of another member state, or even of a third-party state, was first seized. This rule aims at avoiding that, through the introduction of two parallel proceedings, the handling of the claim will be blocked or slowed down. Since the court competent to decide on jurisdiction was simply the one first seized, this allowed for astute litigators to delay the procedure by quickly starting proceedings before jurisdiction, reputedly moving slowly, or not handling issues of jurisdiction on a preliminary, separate basis. This was known as the Italian torpedo. Let's put an example. Parties A and B agree in the contract to litigate any disputes before the courts of Vienna. The dispute arises in which B is the one at fault. In an attempt to gain time, B hurries up and by surprise sues A in, let's say, Milan. A responds by suing B before the courts of Vienna, the forum that had been agreed. Of course, the courts of Milan have nothing to do with the case and will probably decline jurisdiction. However, Italian courts are known to be slow, particularly when dealing with jurisdictional issues. Under the current regime, the court of Vienna has to stay the proceedings until the court in Milan decides whether or not it has jurisdiction. The litigation has thus been successfully blocked for maybe a couple of years. Under the new rules, however, it is the courts in Milan that will have to stay the proceedings, even though it was seized at first. It doesn't matter anymore which court is seized first. The court designated in the forum selection agreement has priority, and all of the courts that may be entertaining the case must suspend their proceedings. Let's see on the screen the wording of the rule which is still applicable. Any court other than the court first seized shall stay its proceedings. And let's compare it with the new rule. Any court of another member state shall stay the proceedings until the court seized on the basis of the agreement decides. In this way, the effectiveness of forum selection agreements, of party autonomy in the arena of international litigation, is significantly reinforced. The effectiveness of forum selection agreement is reinforced also in a few more aspects. Firstly, by setting out expressly the separability of the jurisdiction clause, so that it shall be treated as an agreement independent of the other terms of the contract. Therefore, the clause will remain valid even if the rest of the contract is not. Secondly, the validity of the clause does no longer require that any of the parties is domiciled in the EU. Under the current regime, it is required that at least one of the parties is domiciled in the EU. This limitation is eliminated. The validity of the forum selection is effective regardless of the domicile of the parties. As you can see, party autonomy in cross-border disputes is significantly more protected. The revised Brussels I regulation effectively reverses the gradual encroachment of the Brussels regime into arbitration that had been initiated by the decision of the ECJ in the West Tankers case in 2009 and had continued with the first draft of the proposed regulation in 2010. After having encountered considerable resistance in the arbitration community, that first draft has been finally changed to clarify that arbitration is absolutely excluded from the ambit of the regulation. The key effect of this clarification is that the court of each member state is free to examine the validity of an arbitration agreement. Likewise, a member state court need not wait for the decision of another member state court on the validity of an arbitration agreement, even if the question was referred to that other court first. Furthermore, in the event of a conflict between an award and a judgment from the court of a member state, the court should apply the 1958 New York Convention in preference to the Brussels regulation and enforce the arbitral award if it's considered valid. Finally, the scope of arbitration has been clarified to include court proceedings surrounding or in support of arbitration, such as establishment of tribunals, interim measures, powers of arbitrators, etc. Whether arbitration is a principal or incidental issue will not matter, and it will still fall outside the regulation. As can be seen, the amendments to the Brussels I regulation are certainly a positive step for arbitration and should give some comfort to parties that arbitration in Europe will continue being governed by the New York Convention without the disturbance introduced by West Tankers. In the West Tankers case, the ECJ implied that any member state could be required to stay its proceedings pending a decision of another member state court who was first seized. Again, the first seized rule, and therefore again the torpedo tactics available. Fortunately, we won't be seeing torpedoes again in this field. Every court will have the right to decide on the validity of the arbitration agreement without having to wait for anyone else. The result of the regulation is a particularly hands-off approach for arbitration in the EU. Every effort has been made to clarify that all matters related to arbitration should fall outside the regulation. A final point may be highlighted as well. The new regulation extends the protective rules relating to consumers and employees to apply also to traders and employers domiciled outside the EU. Having made this final remark, we have completed our review of Brussels I regulation recast. Remember, no exequatur and no torpedoes against either litigation or arbitration proceedings. Thank you very much for your attention, and goodbye.